May I please, my lord?
Yes.
Lordship, I beg to mention item number 3. Lordship, here actually the pleadings are completed. However, your lordship, the central government have filed an affidavit bringing some new facts. So, lordship, I have sought some instruction from the department, which I'm yet to receive, your lordship. So, some time may kindly be granted to me, my lord.
Objection? No.
Short time may be given because it is regarding pending. We are shifting the burden. The state is shifting the burden to the union. Where is the union shifting the burden to the state?
Passing the buck.
Yes.
Mr.
N. Angami, my
N.
lord.
Angami,
Lordship.
Learned Government Council submits that after perusal of the affidavit filed by the respondent.
State respondent, your lordship.
No. After affidavit filed by the
Union of India.
Union,
Lordship.
on perusal of the affidavit filed by the Union of India, that is respondent
Number 5, my lord.
number 5. There are certain issues which needs to be clarified, for which he requests to obtain instruction from the state government. This stuff. Therefore, he pressed for some time so as to enable him to obtain, so as to enable him to seek instruction.
Lordship.
This stuff. Mr. So-and-so, learned counsel for the petitioner, has no objection. However, he submits that should be for a short period. Mr. The prayer is allowed. List this matter after
Lordship,
2 weeks,
Lordship, if they can accommodate me 3 weeks, my lord.
3 weeks.
Just for instructions, I don't think.
Lordship,
Instructions, so they have not the same.
Yes.
2.5 weeks. 3 weeks.
I'm deeply obliged, my lord. Deeply obliged.
List after 3 weeks.
Lordship, I also have beg to mention item.
You just mention what, how many matters you want to mention?
Just
the number.
the last one, your lordship, 31, 32, and 33 from the hearing list, your lordship.
No. This is what? 31?
32 and 33.
No, this is 2017-16 matter. No
Lordship,
adjournment.
Subsequently, it is on 2022, your lordship.
Hmm?
Your lordship, in fact, what happened is for some other matters, your lordship, there is hearing number item 28, 29, and 30, as well as for some for another part matter there, your lordship. I'm not ready with this matter today, your lordship.
You should be ready.
Lordship, I'm really sorry, my lord.
2016-17. What is the matter?
Lordship, it pertains to cancellation of the land pata permit, not pata permit given to the petitioner, your lordship.
Why you have cancelled it?
Lordship, it belongs to us. There is the issue.
Tomorrow. We'll see tomorrow.
Lordship,
It's 2016-17 matter. No adjournment.
No, your lordship, in fact, 2000 item number 33, that is 2022. If this matter is disposed of, your lordship, this matter will cover 58 and 207 2016, your lordship.
So you want that it should be this 88 should be heard first.
First, your lordship. Yes.
Petitioner? Which for the
Lordship,
petitioner?
Lordship, I'm appearing for respondent number 6 in WPC 58.
Okay.
That is item number 31, Lordship.
Hmm.
Lordship, I'm for the petitioner, Lordship.
Do you have any objection?
No, your lordship.
But this court has an objection. That is 2017-16 matter.
1 week time, your lordship. Just a week time. Because tomorrow the private respondent has some issues, otherwise, your lordship.
Huh?
For me, your lordship, tomorrow I don't have any problem, provided the.
What about tomorrow?
Lordship, I have difficulty tomorrow, Lordship, if that can be.
You are
posted
ready
next-
today.
No, Lordship, I'm ready today, but since the consuls are not ready today, if the matter can be posted next week, Lordship, any of the date.
Next week.
Lordship.
And your lordship, there is an intern.
You have no objection, will not extend the interim order. Mr. Enangami, Government Council President submits that he has some difficulty today. The request for listing them up after a week. MS so-and-so appears for
Respondent number 6, Lordship.
MS so-and-so. For petitioner, learned counsel petitioner has no objection. List of this court noticed that writ petition 207/2016 and 58 of 2017 has been pending for the last pending for last 5 years. However, on being pointed out by the council, state council, that the analogous matter is of 2022. Though this court is not inclined to grant further time, our interest of the justice, for the interest of the justice, list this matter after a week, for which
Your lordship,
it
please
is made
expedite.
clear that no further adjournment will be granted on the next date.
They will.
Oblige,
Most
Lordship.
pleasure.
Interim order plus arrest will continue.
May I please your motion?
Yes.
Your lordship, I beg to motion here in item number 34.
34. Yes. What do you want?
Your lordship, maybe after a week.
Why?
Your lordship, actually here in this case, I've filed an affidavit for withdrawal from the Kalaknama, your lordship. However, this honorable court is of the view that I have to serve notice to the petitioner before withdrawing the Kalaknama. So, your lordship.
What is the matter?
Your lordship, here the petitioner is challenging her termination order.
Termination.
Yes, your lordship. However, your lordship, unfortunately.
Have you given a notice to the
Yes.
petitioner? You are for petitioner.
Yes, your lordship. So, for withdrawal of my Vakalapama, I have already served notice, your lordship. However, when the matter was listed on 18/7/2023, your lordship, I have made a wrongful submission before this honorable court that steps was already undertaken for service of notice upon the petitioner. It was due to a miscommunication with my colleagues, your lordship, so my humble apology. And I have taken step on
In that case, we'll fix the matter. Next week, you make a contact your client over the telephone.
Your lordship, I have been trying to contact her, but she's not responding to my calls, so. And that is the reason why I'm withdrawing my Vakalapama, your lordship.
It's very difficult.
Actually, this matter was already handled by another council, your lordship. However, the council has unfortunately expired. So after his expiry, the petitioner has engaged me, your lordship. And I filed my Vakalapama only last year, December. But after filing my Vakalapama, I am unable to communicate with her.
May so-and-so learned counsel to the petitioner submits that he has, as he has issued a notice to the petitioner informing that she's withdrawing from the matter, withdrawing from the case in view of the on the ground that the petitioner has refused to cooperate with her Mr. Since the matter is of 2017, list this matter after 2 weeks. So as to enable the learned counsel for the petitioner to place on record to inform this court about the steps she has already taken regarding withdrawal from the case. Mr. MS so appears for state respondents. List this matter after.
Your Lordship, it may be reflected in the order that I have made a submission on before this honorable court that I took steps, Your Lordship, on 18th of this month. However, I've taken steps only on the 21st, Your Lordship.
Before her name. Before the allowing that thing, huh? She also submits that she has taken steps on 21st,
Yes, Your Lordship.
7/20/23 by issuing a notice to the petitioner
Yes, Your Lordship. Through registered ID.
to register it. In that case, 3 weeks. If
Okay.
the petitioner is not interested after termination of his or her service, what can we do?
Yes, Your Lordship.
3 weeks.
Deeply obliged.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item 35. Your Lord-
Again, 2017 matter. What is the matter is all about?
My senior has some personal difficulties to this. And I pray that this matter will be listed after
What
two-
personal difficulty? What difficulty?
he has some matter in the other court.
Huh?
He has some matter in in court one.
That is not difficulty. What is the matter?
Your Lordship, I'm not in this case, but my colleague is ready, Your Lordship, for hearing.
Is ready.
Yes, Your Lordship.
We'll see after some time. Let the matter come. Okay.
Your Lordship, I also beg to mention item 5 and 6. On behalf of my senior, Mr. Gauhati for CGSC, we have filed our affidavit and signed it for vetting. However, we have not received it. back
5
to-
and 6.
5 and 6.
Petitioner.
In this matter, I'm for the private responding in both the petitions.
Okay.
I may also be allowed the same amount of time to file a rejoinder to the affidavit in reply file of petitions.
You want to file a reason there
Yes.
to the affidavit in reply.
Yes.
Is it
Fresh factual
is it permissible? Otherwise, it should
Yes.
keep on.
No. So fresh factual
Then
allegations.
she may ask for another rejoinder to your rejoinder.
That will be subject to the advice that we render. But as far as I'm concerned, they are not to rebut those.
Has they brought some?
Yes.
Do you
Fresh
think-
factual allegations have been made.
That is not admissible. By a rejoinder, he cannot. So
So
therefore,
now
no
that
rejoinder
they
is
are not to
required.
rebut those statements.
It's a writ petition.
It's a.
Why should file a rejoinder? It's not, it will not be accepted at all. If he brought out a new,
No, that's their statement.
Issue.
So as I mean, we are not, so there's no prejudice when it goes to me, I mean, we are not to rebut those.
so that cannot be rejoinder, you just make the submission. Your submission will be taken not
In
on,
that case, your lordship may record that may be ordered.
no, will not say, because it's not permissible. Suppose the petitioner brought a new issue, which is not pleaded in the,
No, it's part of the pleading thing. It's part of his issue. It's part of the issue.
so in that case, as I said, if you file a rejoinder, and if she wants to file a rejoinder to rejoinder, what will happen? Again, you will,
No,
that will keep on.
no.
That's the reason why it is not permissible.
As far as I'm concerned, the allegations, the factual allegations are new, not made in the written petition. So I have not been given the opportunity.
Will not say anything about rejoinder, will say appropriate steps, whatever
Then in
instruction.
that case, additional affidavit
You are
for the private respondent. In both the petitions.
MS,
Asikira on behalf of Mr. Gauhati, CGSC,
so and so, learned counsel for the, appearing on behalf of
Union of India.
Mr. Yangarvati,
Yes.
learned counsel for the respondent number
8 and 9, 9. 8 and 9.
8 and 9.
There is a private respondent, sorry.
Submits that she may be allowed to
6 to 8.
file control, she may be allowed sometime to file affidavit in opposition. Mr.
And
N. Iralo, learned counsel, appearing for respond number
8 in the
8,
first item and 9 in the second item.
also prays for sometime to file appropriate application, appropriate reply, appropriate affidavit to the affidavit in reply filed by the petitioner. Mr. Prayer not being objected to by the learned counsel for the petitioner. You just mentioned her name, Mr. So-and-so, MS so-and-so, appearing for petitioner. Please stop. Prayer not being objected to by learned counsel for the petitioner. This matter after 3 weeks. Prayer is allowed and this matter after 3 weeks. Huh?
Lordship, I may also be able to mention item 19.
19
Yes. This matter can be posted after 2 weeks.
on the prayer of N. Iraro, learned counsel for the petitioner.
Lordship, at the same time, let the interim to be continued.
You are for
For the respondent number 2.
respond number 2, press this. Press for and granted 2 weeks time. This matter of the 2 weeks.
After 2 weeks.
I'm obliged.
Mr. So-and-so appears on behalf of learned counsel on behalf of petitioner. Interim order pass order will continue.
Much obliged.
May I please your lordship. Lordship, I beg to mention item number 4, lordship. The principal counsel is indisposed, lordship. Let it come up after next week, lordship.
Mr. So-and-so learned counsel for the petitioner submits that the leading counsel in this matter is indisposed. Therefore, press for listing the matter after 3 weeks. Mr. So-and-so learned counsel for the respondent 1 and 2 has no objection. Praise the Lord, list this matter after 2 weeks, 3 weeks.
2 weeks.
2 weeks.
May it please your lordship. Lordship, I will mention item number 38, your lordship, for hearing.
Huh?
Item number 38, your lordship.
38.
Yes, your lordship. Lordship, I paid that the matter be posted after 2 weeks, your lordship.
Why?
Lordship, here the matter was being handled by Madam Nasi, your lordship, and it had been. I think we have endorsed the case. My colleague is leading the case. If he's interested, I think she's ready. Lordship, after 2 weeks, your lordship.
On the prayer of the learned counsel for the parties, list this matter after
2 weeks, your lordship.
2 weeks.
Lordship, I also beg to mention item number 43, your lordship.
43.
Lordship.
Same prayer.
Your lordship, if the matter can be posted on that date, your lordship. I've taken the consent from the opposite party, your lordship.
Posted on?
That date, your lordship.
Huh?
That date, 8th of August, your lordship.
8 of August.
I'm appearing on behalf of Hiba, your lordship. He has his feet in another court.
Just record his name or her name.
Lordship, also beg to mention item number 7, your lordship. Lordship. Lordship, if the matter can come up on that date, your lordship, 8th of August, your lordship. Here, the lordship, the NI council, they have appeared, your lordship. In the instant matters, your lordship, they have made a submission that new NIA council was to be appointed, your lordship.
On the prayer of Mr. So-and-so, learned counsel for petitioner, list this matter on 8/8/2023.
Kindly 8 and
Huh?
8th of August.
8 of August. Mr. So-and-so.
Satyanarayana, senior PP.
Huh?
Senior PP and I, Satyanarayana.
Name, please.
Satyanarayana.
Satyanarayan. Learned senior CGSC,
Senior PP.
senior PP. Is there provision under the CRPC like senior PP? Huh?
PP is being again promoted to senior PP.
Either PP or additional PP or assistant PP
But it is.
under the CRPC.
Yes, then that's it.
If you are using the PP, You cannot, overreach the provision of the law. Tell the central government.
ED, CBI, this is a.
Make it senior additional advocate general or super senior additional advocate general or whatever, senior counsel, whatever. You have a right to designate, authority to designate, but not beyond the
Beyond the
CRPC or above the CRPC. You are the central government, you can amend that also.
That is for-
CRPC, if you want to have a senior PP. It's okay.
My please, your lordship.
Yes,
Lordship, I beg to mention item number 16.
16, yes.
Yes, actually, lordship, only this morning I received affidavit in reply, so kindly grant me 3 weeks time to file my affidavit in opposition, lordship.
You have replied, received the affidavit in reply.
Yes, only this morning, lordship.
You want to go through?
Yes.
Why reply to reply? Huh? Mr. So-and-so, learned counsel, appearing for respondent number
To lordship.
2, Samit says he has received the affidavit in reply only this morning. Please stop. Therefore, he prays for some time to take appropriate steps.
After 3 weeks, lordship.
Stop. And for the phrase for listing the matter after 3 weeks. Mr. So-and-so, learned counsel for the prisoner has no objection. Please stop. List this matter after 3 weeks.
So there's an interim, lordship.
Interim shall continue, interim order pass.
Yeah, please, your lordship. Lordship, I beg to mention item number 39 to 42, your lordship. On behalf of the council for the appellant, your lordship. Here, the appellant, council for the appellant, Tai Chuba is on bereavement, your lordship. So I pray that this matter may come up after 2 weeks, your lordship.
On the prayer of Mr. So-and-so, learned counsel for the petitioner.
I have instruction to appeal on behalf of the respondent claimant. However, I am yet to receive the memo of appeal.
Okay.
So direction may be issued to appellant to furnish the copies of the appeal memos.
39 to 42.
39 to 42, your lordship.
You are for petitioner,
Yes,
appellant.
appellant, your lordship.
Mr. So-and-so, learned counsel for the petitioner, appellant submits that. Prays for listing the matter after 3 weeks.
2 weeks, lordship.
2 weeks. Mr.
What is your matter?
What is learned counsel for the learned counsel submits that. He has an instruction to appear on behalf of the claimant in all the appeal.
Respondent claimants.
Respondent claimant in all the appeal. However, he is yet to receive the copy of the appeal.
Yes.
Appeal memo. The next para, the learned counsel for the appellant is directed to furnish requisite copies of the memo of appeal to Mr. So-and-so, learned counsel for the claimant respondent. List this matter after 3 weeks. 2 weeks. 2 weeks, 3 weeks, 2 weeks.
Lordship, I am yet to file my baccalaureate.
Anyway, we accept
After
your
4 weeks,
submission. You file. You file.
Obliged, Lord.
Yeah, please, Lordship. May we please to mention item number 22 to 27, your Lordship.
Hmm.
Your Lordship, I need to receive instruction here. Your Lordship, so 4 weeks will be granted to me, your Lordship.
Orders.
Orders, your Lordship. 22 to 27, and your Lordship, even in supplementary 46 to, in supplementary item 46 to 56, your Lordship, it's an all analogous matter, so let all this matter be clubbed together, your Lordship.
It's 2023.
Yes, your Lordship.
Regularization.
Lordship,
Lordship.
On the ground of,
Lordship, a similar situated person of 2010 and 13 batch were also regularized. That is in total 2,290 teachers. Those were appointed under SSA. And we are also we were appointed under SSA.
MS so learned council, state council submitted. She is yet to receive the instruction. List of yet for principal. Listing the matter after 3 weeks.
4 weeks, Your Lordship.
4 weeks. List of Mr. So learned council to the petitioner.
Lordship,
They are not being objected to by the learned council to the
No,
petitioner.
but the matter in the supplementary list, Lordship, it may be tagged along with the matters that are listed in the daily list.
That's why they have not been objected to learned council by petitioner Mr. So list this matter after 4 weeks.
Much obliged.
So as to enable the state council to file the affidavit. You take along with this. The item 22 to 27
22 to 27
and
and
then supplementary
46 to 56.
46 to 56.
should be take together.
Much obliged.
This, you just say this 20 227 along with this supplementary. Along with the
Notice, Your Lordship,
yes.
I beg to mention item number 18.
Ah,
My Lord, the petitioner is compelled to withdraw the petition
why?
as a state have delayed in filing the affidavit. And before the state to file the affidavit, the NSA first detention order was passed.
Your Lord- Your
You
Lordship,
are very bad.
Your Lordship,
Why you are compelling
Your
the
Lordship,
petitioner to withdraw the petition because of delay?
is misleading the squad. When I was adjourning the matter, he was absent on that day, Your Lordship. And with the bona fide belief, I
Anyway.
adjourned for 3 weeks, Your
Anyway,
Lordship.
he's just asking for, well, not mention the ground of withdrawal. We'll just say that you are afraid for withdrawal of the matter.
My Lord,
It's become infructuous, in fact,
infectious,
in view of the passing of the detention order,
Extension.
extension of detention order.
first extension order.
Is that what is the, under what law? Preventive detention. Detention under what law?
Your Lordship, I didn't get it.
Under what law?
And
Why under what law the petitioner has been detained?
Your Lordship, if we go by
Is it
the
NSA?
NSA, Your Lordship.
NSA. It should be before the division bench.
Yes, that is the order. That's why I also intimated that it should be before
What
the
to do?
DB, but
This is a matter of to be
No,
listed before division bench.
After filing only, I am told that it has to be listed before the DB.
So in view of this, list this matter before the appropriate division bench.
Lord, I may be allowed to withdraw since it was infectious.
No, since this is a matter to be taken up by the division bench, I cannot pass an order. So list it on Monday, you withdraw on Monday. Is it?
Okay, my Lord.
This matter relates to it is this 18, no?
18.
Yes,
Your
okay, my Lord.
Office note dated 19/7/2023. Reflection in view of the order number 37 dated 8 June 2022. The letter request to be listed before the DB. Accordingly, list this matter before the division bench on Monday. Monday is 31st. Withdraw on that day. All right.
Much obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 44, Lordship,
44.
on behalf of N. Angami, Lordship.
Lordship, he is unlike in court number one, Lordship. So Lordship, he has requested to list the matter to pass over for a day.
What is the matter?
Lordship, here the petitioner is aggrieved by the recovery of excess withdrawal of pay, Lordship.
Okay. Excess drawal.
Lordship,
When you
To pass over for a day tomorrow.
list this matter on the prayer of Mr. So and so, Leonard Council, for the Estate Council, list this matter on 28, 27, so and so.
Lordship.
What is the amount?
14 lakhs, 90,000, Lordship.
You are working as,
Lordship, in fact,
you are retired now.
the petitioner has, the last husband of the petitioner has been retired, Lordship.
Okay.
And because of the pension process has been stayed, because of this order, Lordship.
Is he still alive?
No, Lordship, he has he has died on 2020, Lordship, while processing his pension, Lordship.
Why? Husband died.
Lordship, since I'm not in this case, Lordship, if the matter can come up tomorrow. Lordship.
In that case, after 2 weeks, after a week,
Lordship.
next week you do. All right.
Lordship.
No.
I have passed a judgment on the issue
Lordship.
in the eternal bench. You try to find out that.
Lordship. Much obliged.
If tomorrow it may be beneficial for you
Lordship.
to go through the judgment. The Supreme Court decision also. Of course, the another issue would be if in case the employees dies, what should be the consequences? You also find that out. All right. It's not simply don't go by this thing because there's a Supreme Court judgment also, which I have referred. So you find that judgment and you will get to know. And next issue is, in case if the employees dies, what is the provision? Tell your colleague also.
Lord.
For effective assistance to the court.
Lordship.
These issues needs to be
Lordship. Much obliged.
next week.
Very busy, Lordship. So I am praying to take up an unlisted matter for Lordship motion. Maybe as last item, Lordship.
What is the matter? What
I
is
filed
the,
it today, Lordship.
what is the urgency?
Lordship, next day, the trial is on 31st, Lordship. And Lordship, I filed today in
What is the matter?
challenge the prosecuting of the case under an act, Lordship.
This is very difficult.
An act, negotiable instruments, act, Lordship. So Lordship, maybe as last item today, Lordship.
Tomorrow, we'll see tomorrow.
Lordship, I have to go back to Gauhati tomorrow. I have,
You stay back tonight. Tomorrow,
Lordship, may kindly allow that.
tomorrow. We are having a division bench at 2.
Okay,
It's tomorrow.
tomorrow.
It's a nice weather. Stay back
Obliged.
tomorrow.
Yes.
May it please your Lordship. Lordship, this is the appeal against a conviction which was filed. And on the last date, I had submitted before your Lordship for conversion of the appeal into revision.
The sentence already you have served.
Yes.
So what remains there?
I was working and I am under suspension. So if I'm convicted, I have the chance of losing my job. I have the chance of losing my job.
What do you say?
Lordship,
He wants that. He submits that this should be converted into revision. Are you challenging the conviction?
I'll
And
challenge.
Revision has a different scope.
I'll
In
challenge-
revision petition, you have a different scope. And appeal, you have a other,
I definitely I'll challenge the conviction because I feel that it's the order of conviction is forgot.
it will remain as a academic issue, discussion only.
Since there is no provision in CRPC for this kind of matter, for appeal in this kind of matter, that's why I am forced to go for revision.
What do you say?
Lordship, in that way of the matter, let them file a fresh lordship, since the matter itself is serious in nature, lordship.
No, I've seen those judgment.
Yes,
I've seen those judgment.
lordship.
It has
Yes.
been decided on, it's not this kind of matter.
Yes, Lord.
Appeal lies. Is it? Appeal definitely lies.
Appeal.
But problem here is you have served the sentence.
Lordship.
In that case, it will remain as an academic discussion.
Lordship.
So all those cases, if appeal doesn't lie, and if you on misreading or misinterpretation of the law provision, if you file in that case only, it will be converted. But here is a case, admittedly, appeal lies. But problem is sentence has been already, you have undergone the sentence.
Yes, Lordship.
So in that case, whether we can say that whether appeal lies it or not. So simply on that issue, we cannot just convert it.
But since there is no provision as such, but I should have a right to challenge this order.
So I'm not
Because I
saying,
am
no,
convicted.
I'm not saying that appeal doesn't lie. Conviction against conviction, appeal lies. If appeal lies, then why we should convert it to revision? Is not it?
I leave it upon the courts and if appeal lies.
In that case, we will issue a notice, this maintainability, that will keep it open. You go further, the judgment which you are relying, it doesn't help you.
Yes, sir.
Those are the cases where appeal may not lie, but then you have filed an appeal, so it is converted into a revision. Do you agree with this court? Have you gone through all those judgments?
I have gone through the judgment.
Just simply, we are not disputing in fact, there is no provision as such for conversion. But then
For the interest.
High Court can convert it. But your case is something different.
Yes, Lord.
Appeal definitely lie, but
Since I'm challenging this order, that's why.
so we'll issue
Can be
notice in
agent
that
of-
case. We'll issue a notice. Mr. So-and-so, learned counsel for the appellant. Also heard Mr. So-and-so, learned counsel for the appellant. And also heard BG Momi, learned public prosecutor for the state of Nagaland. The present appeal has been preferred by the the present appeal has been prepared under section 374 of the CRPC, 1973, assuming the judgment in order dated 11/4/2023, passed by the special judge within bracket POXO, bracket close, Nagaland, in JR case number 12 of 2022. Corresponding to the, arising out of Woman PS case number 001 of 2022. Whereby the appellant has been convicted under section 354. Within bracket A, bracket close, capital A, bracket 1, bracket close, bracket Roman 1, small Roman 1, bracket close of IPC, read with section 12 of POCSO Act and sentence him to 1 year, 1 month, 1 year and 1 month and 3 weeks. Mr. It is submitted that the appellant has already undergone the sentence. Undergone or it's undergone.
Actually, during the period of trial, he was in jail.
Okay, anyway,
He was
he has
never released in-
already undergone the sentence
And that
imposed
was
by the court below. Mr. Next paragraph. It is noticed next paragraph. In view of the appellant already undergone the sentence, comma, the maintainability of the appeal in the present cases. A maintainability has been raised by the learned counsel to the learned public prosecutor. Mr. The issue of maintainability will be heard on the next date fixed. Mr. Next one. Issue notice. Not issue, is there, respondent is there,
No, sir.
private respondent is there. Issue notice returnable with 3 weeks. Call for the LCR. Huh? No, call for the LCR, Mr. So and so learned counsel citizen shall take steps for service of notice upon respondent number 2. By this respondent number 2. Huh?
accepting first.
No, he's one. Lost. Respondent number 2, you'll have to. By registered with it, registered post with edit within 2 days. List this matter after.
Lordship, I'm allowed to
3
serve a copy, extra copy, Lordship.
Before that, the learned counsel for the appellant shall furnish extra copies to the extra copies of writ appeal, criminal appeal to the learned public prosecutor. List after 3 weeks.
Lordship, date may be fixed.
3 weeks after 3 weeks.
First week of September.
September.
First week.
Then in that says 4 weeks. Call for the CD. 439.
Lordship,
Offense.
kidnapping under section 365. The punishment which may extend to 7 years, and one is 506, which is criminal intimidation, and it's a bailable offense.
Mr. So-and-so learned counsel for the petitioner. Learned counsel for the, heard Mr. So-and-so learned counsel for the appellant. Also heard Mr. BG Mobi, learned public prosecutor for the state of Nagaland. Next para.
Lordship, a date may be fixed if possible.
This is an application under section 439 of CRPC, 1973. Praying for enlargement of the accused person on bail in connection with GR case number 314 of 2023, corresponding to Majifema PS case number 0009 of 2023 under section 365. Public 506 oblique 34 IPC, 1860. Issue notice, call for the CD. Call for LCR or CD?
CD. Lordship.
CD.
May be fixed on 1st August, Your Lordship. It's a
Notice.
Majifema case. It will take only a few hours, Your Lordship.
Please stop. Next para, call for the CD. List this matter up to. List the matter up to
First of August, your lordship.
not 1st of August.
Oblige, your lordship.
What is to be reviewed?
Yeah, please, your
Learned
lordship,
additional AG. By whom?
by the state. Your lordship here, the review was done against a one command judgment. So your lordship here, IA 63 of 2022. It is connected with the civil review petition 6, arisen out of WPC 237 of 2018. Then followed by the IA civil 64 of 22 is relating to the civil review petition 7 of 2022, arising out of WPC 201 of 2017.
Yes.
Then again, IA 65 is civil review petition number 8, arising out of WPC 202 of 2017. So lordship here, the opposite party shares in the respective repetition. They have demanded for the increments that have earned during the work charge service. So since all those three respective petitions are analogous, so it was heard together and passed by this honorable court by a command judgment order dated 29/19, and with the direction to consider the case of the petitioner to consider within the 5 months. That was the direction given to the state respondents. So the CDC copy of that command judgment order was made available on 24 September 2029, and CDC was obtained on the 25th September 2029. Then lordship here is the state respondent will have to go through so many administrative procedure. So it was say last part of the September 2019.
Where 2029, we're yet to reach.
Yes.
Huh?
Then again, when we started the administrative procedure, again, Christmas holiday comes, of course, it does the ground, but we are in the human society, so it affects the working system. Then after that, the direction was, the honorable court was to consider the matter and complete within 5 months. So again, as a way to resume, again, COVID-19 started. The Honorable Prime Minister of India has declared 24th March 2020 as a national curfew, followed by a nationwide lockdown from 25th March from the till 14 April, and it keeps on extend, and we have so many notifications of our Honorable Gauhati Court. Again, even the apex court of the Supreme Court has given the notification.
So there is a delay in filing the review.
Regarding, yes.
IA is for delay.
Yes,
Conversation of delay.
delay.
Of how many days?
960 days.
60.
960.
960.
So, your lordship,
Have you filed an objection?
Your lordship, as far as I is concerned, I don't have any objection. Why? Because while my contempt was pending, your lordship, they issued an office letter where stating that where the earlier honorable court, your lordship, where they have crossed the same order, they have issued the same office order with a different date, your lordship. So on the basis of that, I filed another writ petition, your lordship. And then again, when the writ petition along with the contempt was pending, they come up with a review petition. So now it has become necessary to be heard the review petition, your lordship.
So you have no objection?
Yes, no objection, your lordship.
What are the IAs? First 8, review petition.
Yeah, IA 63.
65 is what?
65 is a review petition 8 of 2022.
We'll take all same.
Analogous, similar.
Analogous. Disposal of the same day.
Yes, lordship. Since WBC 201 and 202, they are different petitioners, but your lordship. But then while pending disposal, the state respondents they file an affidavit including some documents. So for challenging the documents,
who are they?
Your lordship.
Who is appearing for those other writ petitions? There's no review against those writ petitions. Order of the writ petition. Why you should bring in all those things?
No bill, but in the process, we have approached opposite parties, the petitioner and the repetition. In the month of April 2020 also, we had a.
So you,
We had
that is, you just tell me this IA 65 one by one. IA 65 is
Review petition 8 of 2022.
for
Your Lordship,
review 8 of 22. This is how many days delay since he has no objection.
same,
Do you have
because it's
No.
analogous.
objection?
I don't have any objection, Your Lordship. But this item number 10, Your Lordship, IE 63 in civil review petition 6 of 2022, Your Lordship. If that is disposed, then it covers all the review petition, Your Lordship.
IA 63.
Yes, Lordship, in
Okay.
civil review 6. Item 10.
Item 10, item 63. Your grounds are mentioned at where? Paragraph?
Paragraph 2, A, B, C, D.
In fact, in a writ petition, if you file a review of the writ petition, there is an order of this court. I think way back in 2010,
Yeah.
where this court, I mean, where I had an privilege to appear as a petitioner. Because since the law of limitation is not strictly applicable in the proceedings of in the 226 application, it may not, you may not have a, you cannot insist that it should be, you should file a petition under section 5. But as a public policy, if there is a delay, the provision can be applied, but then it is not necessary to file a section 5 application. Have you come across?
No. But, Your Lordship, but unless
I'm-
this section,
In
section
that
5 is
case, in
applied
that
in
case,
the spirit. There's no
in
alternative.
that case, you did not file an application under section 5, but you may explain the delay and taking the provisions of the Limitation Act, the writ court can condemn the delay, but not where filing a review petition.
Your
So I
Lordship,
want
yes,
both of you to go through those judgment, that order. Because it may give a real signal that in review petition, this review is a
Yes.
part of the proceedings of the writ proceedings,
yes,
extension of writ proceedings.
yes.
So when the requirement of filing a separate petition under section 5 of the Limitation Act, which is admittedly strictly it's not applied to the writ proceedings. There's a reason the concept of this delay and laches in the writ proceedings. Are you getting my point?
Yes, Lordship.
So I think, if there is no urgency, we'll fix this matter after 2 weeks or 3 weeks, go through the judgment.
Okay.
Order and, I may share with you if you don't get it. It's a eternal bench by Justice, Honorable Justice I.A. Ansari. I may be, I don't exactly the thing, but then it my memory supports me, that is the law, as on that. Because today, if I condone your, the delay under section 5, it may have a implication in future.
Yes, sir.
I'm not saying, this court is not saying that the delay should, there should not be any delay. Delay should be condoned, but not under section 5. What do you say?
Your Lordship, further though, I don't have any objection, Your Lordship, but then if they've clearly stated that in the review petition, then if the IA can be withdrawn, then I don't have any objection on that also, Your Lordship. If they withdrew the IA, Your Lordship, I don't have any objection on that also.
No, I'm not saying that they should withdraw. I'm suggesting
an-
that it fix the matter of the 3 weeks. You go through those orders
Yes,
and
yes.
we'll decide the matter.
Yes, Lordship.
After 2 weeks or 3 weeks.
And
2
the
weeks.
meantime, Your Lordship,
Let us take it after 2 weeks.
Your Lordship, here, another technically involved here is a review on order 47 CBC. So review has to be taken by the same judge. So whether there is an administrative order from there,
Passed by whom?
there's a judge.
There's an order.
So if there's an
view
administrative
of
order
the,
from the CJ, then there's no doubt.
The meeting of the office by the
Yes.
learned judge who has passed the order, any other judge can take up.
The registrar will take step.
There's the order.
Yeah.
So is there any other respondent?
No.
You are appearing for all the
Yes.
respondents. So in view of this, otherwise, I understand you don't have any objection. But then these are the things which we
Yes,
should kind of streamlining the procedure in accordance with the law. Correct?
In the meantime, direction will be given to the registry regarding the,
What?
or there is a direction from the,
Huh? No, there's already a note. I'll just show you. Administrative order 14/6/2022.
okay, Lordship.
Review petitions and so other analogous matter. There's a order. Mr. Impri himself, learned additional agent. Learned senior additional agent, additional agent. For the applicant. Also heard Mr. Subangmati Wali, learned counsel for the opposite party, writ petitioners. The applicant has filed this batch of application under section 5 of the Limitation Act 1963 for condonation of delay of 960
960
in filing the connected review petitions. This court is of the view that since the review petition against the judgment and order passed by was in the with proceedings under Article 226 No, no, what is the sentence? This quote? No, no, okay. This quote is of the period. The Section 5 of Limitation Act may not be strictly applicable in proceedings under Article 226 of the Constitution of India. The filing of separate petition under Section 5 of Limitation Act may not be necessary. However, if it may not be filing a repeat petition against the order of the court under 226 application may not be necessary. However, the delay needs to be explained even for review, as the limitation has been passed under the public policy of the state. This court privacy of the builder. Same, the privacy builder issue needs to be, it needs elaborate deliberation. In view of the above, this matter after 2 weeks. 3 weeks. On the next date fixed, the learned counsel for the parties may place the appropriate public relevant orders of judgment in this regard. List this matter after 2 weeks. On that ground, will this say, if you can say that no, it's application under Section 5 is required, then we'll pass the order. Because these are the issues we need to settle in the process.
Yes,
Item number 13.
I've been informed by my friend for the respondent number 4 that they have already filed the affidavit in opposition on behalf of respondent number 4, that is the Office of the Accountant General, but I have not been served with a copy of the same.
So, sir, why should keep yourself?
Since our police lordship, we will first survey tomorrow, lordship.
On the prayer of the learned counsel to the parties, list this matter after 2 weeks.
Lordship, I also have a prayer. Lordship, I'm appearing on behalf of my senior. So if his name can be reflected in the cause list, lordship, as the standing counsel of AG, lordship. Joshua Shekil.
Next prayer. MS so submits that she has already filed a counter affidavit. Learned counsel appearing on behalf of respondent number 4.
Lordship.
Submits that she has already filed her counter affidavit. The copy of the counter affidavit shall the learned counsel by the respondent number 4 shall furnish the copy of the counter affidavit to the learned counsel for the petitioner during the course of the day. Do you have the copy today?
Oh, no, lordship. I'll serve them tomorrow, lordship. I don't have it.
By tomorrow. Have you filed? You have also filed?
Yes.
Affidavit. Mr. So-and-so, with Jimomi, Learned Council for the Future. Learned Government Council has also filed it. As Samir, he has also filed the counter affidavit. This matter after 3 weeks.
Which of question?
No, please, Your Lordship. Your Lordship, the present IA has been filed praying for suspending the operation of the review judgment and order dated 23/9/2021, passed by the Honorable Member and the Civil Director in MSC 2020.
Have you deposited?
Yes, Your Lordship, I deposited.
How many? How much? Statutory or all the awarded amount?
30% of the allotted amount.
You have deposited?
Yes, Your Lordship. The opposite party has already returned the money.
Huh?
Even the opposite party has returned the money.
What about the service?
This.
Is the 30% as per the direction of this court?
Yes, Your Lordship.
30%?
Directed by the parties on the court on the 9/3/2023.
Which put petition, Clement? Has the notice
Yes, Your
been
Lordship.
served?
Already filed Balaban.
Huh?
Yes, we are filed with Balaban.
You are for appellant.
Yes, for Balaban.
Which for Clement? That's why I'm asking whether notice has been served or
Yes,
not.
Your Lordship, we have served the notice.
Where it is? Where is the office notes? Showing that this has service completed. Why they are not being shown then in that case? Where it is? It's not showing. B N Sharma. Third, I'm a so and so. Learns counsel to the appellant. Now appears for the respondents. Stop. Next para. By filing its application, the applicant appellant has paid for suspension of the operation of the judgment and order dated 23/9/2021, past the day. Member Motor Vehicle Motor Accident Claims Tribunal, Mokukchun, in MACT case number 20/2028. What is the ground that it should be suspended? What are the grounds?
For suspension of the.
Yes.
The court was inclined to suspend the operations, provided that the appellant suspend the deposit 30% of the allotted amount. Within a period of 60 days.
Where it is?
The Lordship, order dated 9/3/2023.
Passed in
Was,
in IA or in the appeal?
The person I was filed on the 9/3/2023.
Next paragraph. Discord on 9/3/2023. As per the following orders, following order. You just 9/3/2023, huh? You just quote following orders, which is quoted here in the, huh? Next paragraph. The learned counsel to the applicant appellant submits that she has already deposited 30% of the awarded amount. On when?
On
What?
29/5/2023.
29/5/2023. And the same has already been withdrawn
Yes, Your Lordship.
by the
By the
claimant,
parties.
respondent. Mr. Next paragraph. Having the submission of learned counsel to the parties and on perusal of the order of this court dated 9/3/2023 referred to above. The comma. This court deem it appropriate to suspend the operation of the impugned order dated 23/9/2021 passed by the learned MSc Mokukshan in MSc case number 20 of 2028.
2018.
2018. Mr. Accordingly, the operation of the impugned judgment order dated 23/9/2021 is hereby suspended. Pending disposal of the appeal. All right. Next paragraph. IA disposed of. Appeal is not listed. LCR call here. In the main appeal, call for the LCR. List this matter up in main appeal, heart so and so, call for the, non appears for the, huh?
For him.
No, known for, admit the, whether this has been admitted or not. Huh? MS so and so, in the main appeal, huh? Admit, learned counsel for the LCR call? No. So and so for appellate. Which the non appears for respondents. This appeal has already been admitted. Wisdom. Call for the LCRs. LCR. This is the matter for hearing in its usual course.
Lordship, I subscribe to my lordship's suggestion that the amount be paid to the petitioner that has been suggested, and the
Admitted.
rest 2 lakhs allow the petitioner to agitate in an appropriate form.
Agree. Then in that case, we'll dispose it of.
Yes, Lordship.
Heard Mr. MS, sorry. Judge Zimomi, learned counsel to the petitioner, and also heard BG Momi. Learned state counsel for the state respondents. Next step. By filing this application, the petitioner pressed for a direction to release an amount of rupees 500,734. 5,734 lakhs only. The balance amount for a one-fit contract work executed by the petitioner pursuant to the work order issued by the respondent authority for renovation, for repair and renovation of 4 within brackets 4 type 1 quarters, comma, duty room, comma, 6-room barrack kitchen and a storehouse at electrical SDO within bracket E capital office Kohima for a total amount of rupees 98592. Next paragraph. The learned consent to the petitioner submits that the petitioner being a contractor and supplier in the state of Nagaland, sorry, registered contractor and supplier in the state of Nagaland, was issued a work order. Well, then give the detailed work order. I will just say was issued.
I have detailed
Seven numbers of work orders.
paragraph 3. Paragraph
Seven numbers of work orders
yes, amounting to 9,85,000.
rupees 9,85,925.29
29 Lordship.
for repair and renovation of 4 numbers of type 1 quarters, etc. The works have already been, the petitioner has completed, has executed and completed the works for which she was, for which the petitioner was for which the respondent authority has released an amount of total. How much you have there?
2,90,000. A total of 9 lakhs.
No, total how much you have received. We'll not go
Yes,
into all those that arithmetic.
Madam, 4,99,000.
4,99,000
998.
998.
Yes.
Where it is given?
Annexer 1, page number 8 in my affidavit in the possession, madam.
You just mentioned, total amount of so and so out of rupees 9 lakhs so and so so and so. Are you following? Getting me? Okay. First, however, the respondent authority is yet to pay the balance amount of rupees 500,734 within 5,730,000. 34. You have given 5,734,000
Yeah,
in your prayer.
They are giving more in their.
Please stop. Therefore, therefore, the petition, the respondent may be, the respondent may be directed to pay the balance amount of rupees 5 so and so, 5 lakhs so and so, so and so.
No, my lord, the
Just,
agreed amount-
this is his, our submission.
Oh, okay.
Just listen. Next paragraph. Mr. So and so. Learned counsel. Your poor state,
Yes, my lord.
learned
E-tip of
additional
form.
lazy,
No, government advocate.
learned government advocate,
E-tip of form.
so and so, by referring to the affidavit filed on behalf of respondent number 1, 2, 3, 4, and 5. Submits that. What is your submission? That she has executed all the,
Yes,
where it is given?
in my paragraph 4, paragraph 4(8).
Just wait, where
In
you
the-
have, where you have said you have, she has only completed amount of rupees, what amount of rupees?
My lord, it is in para 9.
We'll just go there, let's forget it,
Yes, para 9.
it's all disputed. Where is para 9?
Page number 5.
Huh?
Affidavit in opposition. Page number 5.
Submits that. Admittedly, the petitioner was awarded 7 numbers of work orders for amounting to rupees 985929, same that total amount. Only by the executive engineer, hydro construction division. List of. Out of total works. Out of total work orders. Out of the value of total work orders, the contractor, the petitioner has executed only a total works amounting to rupees 783,916. Where payment to the petitioner amounting to rupees 49998. 4,99,998, which was released as on 31/3/2021. Mr. He further submits that the only outstanding liability is rupees 2,83,918. For which the authority shall pay as and when there is a availability of the fund. Mr. Next paragraph.
Lordship, to that, if my lord can kindly quote my
No,
submission also.
that is his submission. What is your submission?
My submission is that I have.
No,
said
we'll say. Next paragraph. MS Judge Jimobi, learned counsel to the petitioner. Contributed the above submission of the learned counsel to the petitioner. Specifically with regard to the
I have repeated 3 times.
amount of regard to the specifically with regard to the execution of work amounting to rupees 7,83,916.
Paragraph 6 of
Mr.
my affidavit. In reply. Just a portion.
And submits that the petitioner has
Out
not
of-
only completed the works amounting to rupees 9,85,929 9,85,929, but also executed an additional work which was asked by the
Lodge.
the authority concerned, Mr. Therefore, submits that she is entitled to the balance on 1 rupees, 5 lakhs, so and so, huh? Mr. Next paragraph. I have considered the submissions of the learned counsel to the parties. Mr. Next paragraph. On perusal of the affidavit, the materials, perusal of the affidavit, records, materials available on the records. Come on. It is admitted, admittedly, the respondent authority had issued a work order, 7 numbers of work orders amounting to rupees 9 lakhs. $85,929 for the works referred to above, works for an execution of the works referred to above herein. Mr. It is also admitted that the petitioner has been paid the amount of rupees 4,99,998 as on 31/3/2021. Mr. According to the state council, state respondents, the admitted amount is rupees 2,83,918. While disputing the balance amount claimed by the petitioner, that the petitioner has only executed a value of an amount of rupees 7,83,916. Next. This court is of the opinion that since the balance amount claimed by petitioner has been disputed by the respondent authorities, this court, the petitioner may approach the appropriate, may avail the appropriate remedy is permissible under the law. Next paragraph. However, the admitted amount of rupees 2,83,918 deserve to be immediately released to the petitioner, which is admittedly not disputed. Mr. Next paragraph. In view of the above, this writ petition is disposed of with a direction to the respondent number, specific respondent,
Lordship,
respondent number, state respondents or the respondent authorities.
Lordship, the Chief Engineer Department of Power will be able.
You are representing all of them, no?
Yes.
Respondent is directed to
Respondent number 4,
4 and 5.
4 and 5. Lordship.
No, in that case, the finance concurrence and all will be required. We'll say respondents,
State respondents. Your
state
Lordship.
respondents
Yes, my lord.
are directed to release the admitted amount of rupees 2 lakhs
83,900.
83,916
18. 918 years.
within a period of two
2 months.
months. Huh? Mr. The petitioner is at liberty to avail the appropriate remedy.
As dear admitted.
As
by
regards to the disputed
2
balance.
lakhs,
Admitted,
2,000.
no, will not say that thing. As regards to the disputed amount
That was
before,
deducted.
in account as may be permissible under the law. That's all.
Lordship. Obliged.
Much obliged.
If there is any confusion, you just you get it correct.
Map is a lordship. Lordship, on the last occasion, lordship, this honorable court has directed the state respondent to go for this video conference, lordship. However, lordship, I would like to place a case diary, lordship. It has been clearly mentioned that they could not conduct the video conference because of the fact that they did not provide a contact number, as well as the petitioner has filed a Zima in this instant petition, lordship. And however, in the earlier, in the NTPS special judge Kohima has rejected the Zima. And here, lordship, they are also praying for Zima of the said vehicle, lordship. However, lordship, I would like to place the relevant case diary, lordship. Here it has been clearly mentioned, lordship.
What is to be done today?
Lordship, here the petitioner, they are praying for the Zima, lordship. However, in the earlier before filing of the instant petition, lordship, they have approached the NTPS special judge, lordship. There also, their Zima petition was rejected, lordship. Lordship, I would like to make it, I would like to place the CD, lordship. I have flagged that.
What is the petition is for? Against the order, or this is for what?
Lordship, here
Who is the petitioner?
Yes, I'm the petitioner.
You tell us, what is this?
Lordship, as said by the Land PB, by order dated 22/5/2023, I was allowed to record my statement through video conferencing since I'm a resident of Andhra Pradesh. And I personally with the investigating officer to record my statement through video conferencing. But IU is not willing to record my statement through video conferencing.
Is there any direction of this court?
Yes, yes, lordship.
Yes,
In fact,
to allow him
yes, sir.
to record his statement.
Lordship,
So BC.
lordship.
Then what happened?
But I conveyed to the IO that whatever documents he needed or whatever personal information he needed, I'll submit to him through hard copy. I intimated to the IO, but still the IO is not willing to record my statement through BC.
Lordship, to make it very clear, lordship, the CD, it has recorded everything, lordship, which I have.
You
flagged.
tell us
Lordship,
where this court should
yes,
look into. No, keep it.
lordship, here the petitioner is saying that the vehicle belongs, he is the owner of the said vehicle, Lordship. However,
That order is 2012-2022.
Lordship.
That is under challenge. Huh?
Yes, Lordship. Lordship, here in this instant petition, Lordship, the petitioner has filed a zimma to release the said
That
vehicle,
has been rejected.
Lordship.
Huh?
They have approached the NDPS Special Judge Kohima, and the zimma petition was rejected. Now, subsequent to that, they are before this honorable court. On the last occasion,
So we'll be requiring the LCR.
no, Lordship.
The challenge is the rejection. Is it? Where is that rejection?
Rejection.
Impugn order?
It's in page 22, Lordship.
Huh?
Page 22.
22.
Yes, lecture 6.
The vehicle shows the meter in which the accused going to be information. Accordingly, have you allowed him to record his statement through BC?
No, Lordship, it is not possible because of the fact that, Lordship, one mobile number was recorded, Lordship, earlier. However, after going through the investigation, Lordship, it is found out that the name was another name, not in the name of this Devram, the present petitioner. And moreover, Lordship, the vehicle also, after going through the investigation, Lordship, the investigating authority, they have sent it to in order to verify, Lordship, they submitted to the RTO, Regional Transport Officer, Lordship, office. From there also, in the Vahan, it has to be in the Vahan, Lordship. The owner's name has to be in the Vahan. But however, in the Vahan also, the name is not there, Lordship. So now the investigation agency is finding very difficult, Lordship. So
allow him to record his statement.
Lordship, through VC,
Suppose,
Lordship.
what is the difficulty is the recording the statement through BC?
Lordship, the problem is, Lordship, here the owner is also not in the name of the petitioner, Lordship.
Whatever.
And then they have.
Is he an accused?
He is not the accused, Lordship. However, the
He is
vehicle.
not
in
the
which-
accused. Petitioner is not the accused.
No, Lordship.
You are the owner of the vehicle. You are claiming that vehicle belongs to you.
Yes, Lordship. Yes,
Okay.
Lordship. However, after going through the Vahan portal, Lordship,
What is the order of this court to allow you to BC, through the BC record?
Yes, Lord.
Yes, Lord.
What is that order?
It's in order dated 22/5/2023,
Where it is?
page 3,
Huh?
page 3. Order dated 22/5/2023, page 3, the first paragraph.
Page 3.
Page 3.
3.
Yes, the relevant portion is in page 3.
Is page 3.
So Lordship, as I have stated, I personally approached the IO and whatever documents he needed pertaining to vehicle or whatever personal information he needed, I will provide him in soft copy, hard copy. And let him record a statement of BC. But the IO is not willing to do so.
Lordship may kindly come to my to the city Lordship, which was placed before your Lordship, to make it very clear Lordship. The flag, the red pink flag. Pink flag, fourth paragraph Lordship. Starting from fourth paragraph.
Now in compliance.
Lordship. May I read Lordship? Now, in compliance with the Honorable Court's order dated 22/5/2023, in connection with criminal so-and-so by the Honorable High Court Kohima bench, directing the investigating officer of the case to facilitate or record the statement, next page, Lordship. Statement through conducting video conference. That, Your Honor, it is to state that the petitioner did not provide contact number to the investigating agency. Moreover, it might be find difficult to identify or recognize the vehicle owner through video conference. So it is my humble request to your humble court to kindly make the petitioner available to the investigating agency for the smooth conduct of the investigation as well as recording of the statement. Since the vehicle registration record, very important Lordship, since the vehicle registration report has not been found in the Vahan portal at the concerned department, that is RTO, and the vehicle was found highly dubious and suspicious. To ascertain of the fact, the investigation agency required the vehicle owner presence as well as original documents from him, petitioner in person for further necessary action. The vehicle was seized by the narcotic personnel on 29/7/2022 for transportation of opium of 10 peg weighing approximately 10 kg, which was recovered from inside the spare tire of the vehicle. And the vehicle was not seized for a mere suspicious, but on sufficient evidence and on reasonable ground that the vehicle was used for transporting of illegal trafficking of huge commercial quantity. Also during the process, the vehicle was booked under Section 60 of the NDPS Act by the registering authority, and it is clearly mentioned in the Act that whenever an offense committed under this Act shall be liable to be confiscated. I therefore pray to your Honorable Court to kindly look into reasons of the above mentioned and redirect the petitioner to appear before the investigating agency for recording of statement to produce documents in original for the evidence at the earliest for necessary action. And Lordship may kindly come to next page, Lordship. This is the CAF call application form, Lordship.
What is CAF?
It's a call application form, Lordship.
Okay.
So Lordship, after going through this, after checking out this mobile number, Lordship, the name, the petitioner's name was.
This is something different.
Yes.
Honor is something different.
Yes, Lordship. And Lordship also.
What do you say?
The flag.
What do you say? You provide a mobile number, how can, otherwise or mail ID, how can you be allowed to avail the VC if you don't provide the mobile number?
And more importantly, Lordship may kindly come to letter dated 14 October 2022, Lordship.
Page,
the last flag one, Lordship.
okay.
It's Government of Nagaland, Office of
Kumar
Regional
Mehta.
Transport Officer, Lordship. A, the present vehicle number, vehicle record not found, Lordship. So has stated.
B is nothing to do it. This is a different vehicle. B
is different, Lordship.
Okay.
B is, so altogether they are.
Number one, you have to give it your number. Mobile number,
Yes.
huh?
Lordship, as I have stated, I personally with the IO. And I'm.
Where is your client?
Lordship,
Where is your client?
my client is from Andhra Pradesh.
Andhra Pradesh.
Yes, Lordship.
Hyderabad.
Andhra Pradesh.
Andhra Pradesh, oh, it's no longer Hyderabad, is in Telangana.
It's Lordship.
Huh?
Hmm.
Andhra Pradesh, which place?
It's at Marakpur. Now, Lordship, now the issue is
Ah.
the vehicle owner is not been ascertained, Lordship, till that.
So there is no question of Jimma,
Lordship,
if
Lordship.
it is not
Lordship.
identified.
Lordship, that has to be
First.
identified first, Lordship. No, Lordship, as I've said it, I'm willing to produce the document.
Produce it,
I'm willing to produce the documents before the IO.
produce
But
it.
I was not willing to accept it.
How you
The IO
can,
is not willing to accept it.
you give your number, I mean, your client's number and get it done through BC and you submit the hard copy, whatever is there, and let them verify. That's
Yes,
all.
yes, Lordship.
What
Lordship,
is this?
the vehicle
So
and-
this petition may not unnecessarily you have filed. Because this court has already allowed you to give the statement through BC. So you tried, but then according to IO, you have not provided the number, mobile number. You provide and you try one more.
Yes, yes. Lordship.
And unless you are identified and the owner is
Lordship,
crossed out,
exactly.
what's the
exactly,
question of
Lordship.
Jimma?
Lordship,
So this petition is nothing.
Lordship. So in that way of the matter, Lordship.
You withdraw
this-
the petition,
Lordship,
nothing remains.
Lordship. That has to be a certain question.
If you can establish, then we can see. Unless that is, this is established and you are ready to give the statement and the records. What is the use of this petition?
Lordship,
Withdraw,
Lordship.
nothing. Because your basic, the challenge is those rejection of application, Jimma.
Lordship.
And the special court found that it's little suspicious and dubious.
Yes, Lordship.
And by the IO, someone is, the owner is someone else,
Lordship.
and you are not able to show it. For that, the statement is required and the documents is required to be submitted to verify. Then only we can see, I mean, the court can see whether Jimma should be given or not.
Yes, Lordship, Lordship.
So until the time you establish or do this before the IO, it's very difficult. So in view of that,
No, Lordship, I'm ready to produce my document, but the IO is not willing to accept
what
it.
do you go there?
No, Lordship, now the issue, the fact remains that Lordship has rightly pointed out. Now the owner, the vehicle owner is in question, Lordship. Who is the real owner, Lordship? Now, even the
No, issue,
investigating
the
agency.
basic is you
Yes.
have the Jimma,
Lord-
you applied.
Lordship,
Court find it to be suspicious and dubious. And this court on your challenging that order, this court has permitted you to record his statement through BC. You have not provided the mobile number. Though as a council, you may have some records to submit, it just cannot be accepted like that. So statement along with all those thing, you first do your job, I mean, the duty which is required to be done.
yes, yes.
Then
Should
we
we-
cannot look into this
In that case, my prayer is,
to allow you to withdraw. If they
No.
are not, if they are not allowing you to go to BC and all, you come back,
yes, Lordship.
you come back, file an appropriate application.
Lordship, let them.
You withdraw this petition, nothing remains.
Lordship, my prayer is, let the IO record my statement of video conferencing and whatever documents in it that I'll
That
produce.
has already been passed. This court has already passed an order. Why you should keep on repeating? IO has responded
Lordship.
after this court's order
Yes, Lordship.
that you have not provided the mobile
Lordship.
number. Without mobile number, how it can be, I mean, all this ID, you cannot be. And number one, you are not an accused.
Lordship.
Why to worry? Give your mobile number.
Actually, I offered to my mobile number also
Huh?
to the IO. I offered my mobile number to the IO also.
Your
My clients. My
clients.
clients.
But
Yes.
what is saying?
He said that he is not willing to record the statement from video conference. So he is not willing to take the contact number also.
That is another subsequent events.
Yes, Lordship.
How do we know?
Yes, Lordship.
Public prosecutor representing the IO is submitting an on written instruction that your client has refused to, has not furnished the mobile number. And in view of the fact situation, your presence is required. So investigation, that's why I'm saying you are not an accused. Agent today, why you should afraid? If you are an accused, we could have given more protection. You could be a witness or something like that. So that's why we have provided you to have that video conferencing facilities. I'm sure the learned people will help you out. Tell your IO to get it, let him furnish the mobile and get it the statement recorded through.
Lordship,
If you record a statement, you may have be able to get some I mean, ways and means to find out the real owner.
Yes, Lordship.
At least record the statement.
Yes, Lordship, but the fact remains that Lordship, Lordship may appreciate the fact that Lordship, once we purchase the vehicle, Lordship, now after registering our number, Lordship.
It so happens, we have
Lordship,
come
it
across
has to
so
be-
many cases.
It has to be in the portal, Vahan portal, Lordship. It's all, Lordship is well aware that it is all over India, Lordship. But Lordship,
See, I have sold my vehicle 10 years back. Still, I'm not sure whether the ownership has been changed or not. As I believe, who have bought taken my buyer, he's my, I have a belief on him. He might not have changed it.
so Lordship has rightly pointed out, Lordship, let them approach the IO and Lordship, let them withdraw the.
You approach, you have, without this, if he is not allowing, permitting you do as per the direction of this court, all right, you come back.
Lordship.
And then PP will support you. And without recording in the order, you just inform the IO to get the statement through BC as directed. Withdraw the petition.
Lordship, actually, I'm not the main counsel. The main counsel is from Gauhati.
This is the case diary.
Lordship, this is the case diary, Lordship.
Then in that case, why you have argued when you cannot have take any decision? Had Mr. So-and-so learned counsel to the petitioner and also Mr. AG Momi. DG Momi, learned public prosecutor. The learned public prosecutor has produced the CD. On perusal of the case diary, it transpires that the petitioner has not provided the mobile number for availing the facility of video conferencing for recording his statement, for which the IO is not in a position to provide the facilities through video conferencing. Though the next paragraph, let me consider the petitioner attempted to argue that the IO is not providing any facilities of BC for recording the statement of the petitioner. The written instruction, not written, the records speaks otherwise. In view of the list this matter after 4 weeks. You are not withdrawing this 4 weeks. So as to enable the petitioner to take appropriate steps as may be permissible under the law. There's no interim.
No,
You provide the mobile number and all those things.
Lordship.
You just keep it pending because you are not the main counsel. Otherwise, I could have dismissed it.
No.
There's nothing.
They will-
It's not that your case that this has been, the order has been wrongly passed. You are agreeing to the order otherwise.
No.
It's up to 4 weeks.
All right.
Yes, Lordship.
Yes.
Lordship, this is for 82 application for questioning the fire on charge sheet.
Yes.
The complainant has also appeared, my lord, today. Lordship, I am for respondent to Lordship,
Okay,
complainant Lordship.
okay. Do you have anything to say?
Lordship, since we have settled the matter amicably, Lordship, I don't have any objection. My lord, the matter is about financial transaction between the petitioner and the complainant.
What is
Their,
the, what is the offense?
offense is 420 and 409, my lord.
Where is that thing? Where's the settlement? Have you annexed the settlement?
Yes, my lord, that
Where
is
it
page
is?
20. 20, my lord.
Hmm. Will dispose of it. Dispose. What do you say?
May close it, lord.
Heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. Jimomi, Jimomi, learned counsel, learned is PP. Nagaland.
Kian kami.
Kayangami, sorry. Kayangami, learned PP. Kamanagaland. Mr. So-and-so and Mr. for respondent number 2. By filing this application under section 482, CRPC, 1973, the petitioner only one petitioner,
One petition, my lord.
petitioner has prayed for quashing of the FIR number 217 of 2015 and its charge sheet number 50 of 2016. In GR case number 910 of 2015 under section 420, 409 IPC. Pending before the
Sejong Dimapur.
Chief Judicial Magistrate Dimapur. On the basis of the settlement not settlement, on the basis of the compromise deed dated 29/09/2022. Next paragraph. The genesis of the matter emanates from the FIR, from an FIR dated FIR, when was the FIR? 15/11/2015, filed by one Sri. No, filed by the respondent number 2, Bisito Sema.
Yes,
Dimo,
my
before the Dipupar police station. Before the officer in charge of Dipupar police station, Dimapur. Which was registered as Dipapur police PS case number 217 of 2015 under section 420/409 IPC, 1860. The police has submitted the charge sheet on 3/4/2006. Which has been in the no, before that, you just said before police, before that. The case has been registered at GR case number 910 of 2015. The police has submitted the charge sheet on 3/4/2016. Next paper. The where's the FIR?
FI is page 9, 11 portions, page 12. Page 11.
Page
11.
A allegation in the FIR. The allegation by the respondent in the FIR is quoted here in below. Page 11. You just quote the FIR. On the mere perusal of the FIR, the allegation is that the petitioner has with the intention to cheat the informant from the very inception, and the respondent two has been duped of rupees 13,50,000. Next page. During the pendency of the case, the respondent number, petitioner and the respondent number two,
Yes, ma'am.
had entered into a compromise deed on 29/9/2022. Whereby the parties have amicably settled the matter on mutual understanding. The learned counsel for the petitioner submits next paragraph, submits that in view of the nature of the offense alleged and the matter being settled through a compromise deed between the respondent number, petitioner and the respondent number two. The continuance of criminal proceedings will be futile. The criminal proceedings in GR case number 910 of 2015, pending before the London CG Dimapur, maybe quashed. List. Next paragraph. Mr. K. Angami, London PP for this state, and Mr.
Sukachi's lordship.
Respondent number two, have no objection if this criminal petition is allowed. Next paragraph. Having considered the submissions of the London Council to the parties and also perusal of the material available on the report. Come on. This court finds that the allegation appears to be out of business.
It's financial transaction.
Out of a financial transaction for between the parties. And subsequent misunderstanding that might have been aroused during the course of their business transaction. The parties, on being realized, appears to have settled the matter by a compromise deed, as reported to you above. Such, in view of the above, That being the position, the security is also due to the continuance of the criminal proceeding. In the present case, will serve no purpose, rather it will be a futile one. Question. Next one. In the case of Madhya Pradesh police and so, Lakshmi Narayan, 2019 something, that will be, you take it from Yezo. Take them. So and so. You quote that paragraph, huh? Madhya Pradesh versus state of Madhya Pradesh versus Lakshmi Narayan. So and so reported in so and so. I think 2019. Do you have
Yes, I have the
2019?
Yes.
Just give the
Yes,
citation
I'll give the citation.
and paragraph.
Yes.
You just got that. Next paragraph. On consideration of the not on consideration. Next paragraph. In view of the discussion made above and law enunciated by the Honorable Supreme Court. Next one. This court is of the opinion that the present criminal petition deserves to be allowed. Accordingly, the criminal proceedings in GR case 910/2015 pending before the under section 420/409 IPC pending before the CGM Dimapur is hereby set as a request. In the result, petition is disposed of, allowed and disposed of.
Hello, Bless.
That's also. Anything else to be recorded? No.
No, man. Bless me.
Yeah, Mr. Lordship.
Yes.
My lord, I may be allowed to make a mention. My lord,
Why, sir? We'll come back at 2.
My lord, since there will be division bench at 2, and my lord, I have some health issues. I thought this matter may reach earlier.
Okay.
So, my lord, item number 28, 29, and 30. I'm appearing for respondent number 6 in item number 28 and 29.
We'll see.
My lord,
It's 2016 matter.
my lord, I have some health issues. I have some problem with my health. So if this can be listed next week. I thought this matter will reach before 2, and then that is how I was waiting for it. But
You are not keeping
my
well.
lord, I'm not so well today.
If that is the situation, otherwise this code is that is
Yes.
2016
My
matter.
lord, yes, my lord.
Mr. So-and-so, learned counsel appearing for respondent number 6.
My lord.
Takakichu, huh? Some is that he's not keeping well. Today. Therefore, President matter may be listed after a week. Petitioner, Mr. So-and-so, which is appears and has put no objection to the prayer in view of the no objection, has put no objection, Mr. In view of the above. List this matter after a week.
My lord.
No further adjournment.
Much.
Huh?
My lord.
Should I say or should I not be in view of the 2016 matter?
I'm fine with it if that is also recorded.
Since the matter is of 2016, no further adjournments will be granted on the next date.
Much obliged.
We'll resume after the division bench.
Computer section, lunch break.
Hah? Hmm. मेरो पनि भप्ना एकदम एक्सचेन्ज गरिकन किन एकदम युज गरिट होइन
Hello.
Hello, hello, hello. Hello, 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 hello.
Bây giờ nó nghe nó. Ek pani risk mai so. Ki. Ek pani risk mai na na tu ko. Kalau risk so. Le te ekta ni lagi tu na. Ekta lagi tu. Do la na. Hello, 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 hello. Uno la uno na. Uno la uno na. Hả? Hello, 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 hello. À? Ở đâu chúng tôi chứ? Ở đâu đồng này chứ? Hello, 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 hello. Tao ngao xuống nhá, microphone đây chứ? Hả? Đây nó không được đâu. Hello, hello, 1, 2, 3, hello. Lệ, hôm nay xin nghe. Đi tiếp đây, hôm nay nghe. Hello, 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 1, 2, 3. Hello, itu mau mungkin live aja itu, lo careful tak ya. Hello, hello. Hello, hello, 1, 2, 3, hello, 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 1, 2, 3. Hello, xin nghe, cùng xin nghe. Hello, hello. Check 1, 2, 3. Hello, check 1, 2, 3. Yes, na. Hello, 1, 2, 3. Yes, na. Hôm nay nghe. Hôm nay nghe. Kita dah ini nih. Speaker on dia. Jauh kota. Itu speaker lah. Ini sana. Oh, ini ada connector na. All feedback kalau play ni lah. Nah, je. Nune, kali lawas. Okay. Nune. Hello, 1, 2, 3. Ini sana.
Itu Rusi tanya baru di mana aku.
Kiwa, itu lambat.
Oh, itu kan Rusi.
Anak dah. Tahu dah. Itu tahu dah.
Masih kalau.
Nah, sama-sama lo berbahaya ini.
Kalau boleh tadi bawa nih lah, mic pernah.
Benar.
Wah. Itu gini aja loh. Itu tinggi nih lah.
Dua lagi.
Itu lama fokus sama itu tadi itu. Gimana tadi mungkin boleh.
Lo close aja. Lo close.
Gan mana guys? Gan saya dulu.
Hello. Ini sana. Hello, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Hello, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Control room. Ini saya. Control room.
Besok di mana kita sih? Kalau kita ada cek kita sih.
Indonesia. Pull out.
courtroom to the courtroom one the microphone change করছে hello oh clear clear okay এটা courtroom to the one যে যাও courtroom one যে যাও okay
Whether this one is under BC Act, doesn't it is this one that is in the- BC Act 9 and there's the thing. RC, not. BC Act 9, not. Will be. So, itu status tu, then kalau itu kan, kalau asas itu coba.
Will boleh subjek. Angin.
Guarantees.
May it please your lordship.
Yes,
Lordship, this is for criminal bail application and it's pertaining to NDPS Act, your lordship.
Mm.
May I please your lordship? Lordship, I'm for the petitioner in this instant case, and the petitioner in this instant case earlier filed a bail application before the special judge. That is on 21st of June. He filed an application and which was put up for hearing before the special judge. Lordship, aggrieved by the order that was passed by the special judge, this present application has been placed before your honorable court.
yes,
Your lordship, on the earlier bail petition, my grounds for the bail application was solely, primarily on the strict sense of the legislature that is enumerated under section 36A clause 1 clause B of the NDPS Act, your lordship, pointing out that the chief judicial magistrate had granted judicial detention to the accused person exceeding 15 days as a whole, your lordship. And that was my main prayer. And during hearing of the bail application, your lordship, the health status of the accused was also placed before the court. But the main ground of appeal, main ground of my bail petition was on contravention of section 36 clause A clause 1 subclause B, your lordship. And that was praised before your before the special judge. The lordship, however, the special judge did not appreciate my prayer and did not afford the slightest of view, giving an opportunity to consider the process, due process and procedural practice of the NDPS Act. And on this ground, your lordship, I have come before this honorable court with this crucial ground, your lordship.
when you were arrested,
Your Lordship, I was arrested on
27/5.
26th of May, Your Lordship. And 24 hours police custody was granted by the SDO Civil Revenue District.
How do we, from where do we get that you were arrested on 26?
Your Lordship, as per the arrest memo, I was formally arrested. Arrest memo is in, Your Lordship may kindly go to page number 13.
Now, madam, in that case, if you are challenging that there is a violation of any provisions of the law, you have to file a revision petition with a prayer for bail. That cannot be a ground for granting you release you on bail. What do you say? Let us see the section 36A. What does it say? Any pace?
Yes, Your Lordship. Your Lordship, it's 36A, that is offences triable by special court.
Yes.
And clause B, I'll read the main section.
Yes, yes,
Clause B,
Just wait, just wait.
where a person accused
Just
of
wait, just wait. 36.
36A, clause B, Your Lordship.
36A. Yes.
Clause B, Your Lordship. Where a person accused of or suspected of the commission of an offence under this act is forwarded to a magistrate under subsection 2 or subclause 2A or section 167 of CRPC. Such magistrate may authorize the detention of such person in such custody as he thinks fit for a period not exceeding 15 days in the whole, where such magistrate is a judicial magistrate, and 7 days in the whole, where such magistrate is an executive magistrate, provided that in cases which are triable by the special court, where such magistrate considers when such person is forwarded to him as aforesaid or upon or at any time before the expiry of the period of detention authorized by him, that the detention of such person is unnecessary, he shall order such person to be forwarded to the special court having jurisdiction, Your Lordship.
Yes.
Your Lordship, in my case, the accused person, he was arrested on 26. Police custody was granted, 24 hours police custody was granted. And on 28, he was produced before the Chief Judicial Magistrate. And on the prayer of the IO, seeking 14 days judicial custody. So the CJM granted 14 days judicial remand. After that, he was brought before the court on 9 of June again. Again, the Chief Judicial Magistrate granted 14 days judicial remand, Your Lordship. That is more than 15 days as a whole, Your Lordship.
As a whole at a time, not further.
As a whole, Your Lordship.
As a whole, not entire period of the thing. That cannot be. It was produced after the completion of 15 days.
He was produced again, Your Lordship.
Then again it was remanded.
Yes, Your Lordship.
Yes. It's correct.
Your Lordship, but this
If I correctly understood the provision which you have relied on. What do you say? As a whole, in the sense, at a time. Because you have to see the NDPS, it's 180,
Yes, Your Lordship.
not 90 days.
Yes, Your Lordship.
So this means at a all. Had it been a case that if you was remanded
Yes, Your Lordship.
on that day for 20 days, it would have violated this provision. It was 14 days, as a whole 15 days.
But Your Lordship, this especially this is a special act. So NDPS being a special act inviting grievous punishment, the due procedure has to be taken.
That's what I'm saying.
This
So what you have
section lies
interpreted is not correct.
prescribable by special court.
This court is not accepting your interpretation of this provision. As a whole means at a time, not more than 15 days. So you, the accuser is remanded for 14 days and he was produced and then again it is remanded. It is next another hall.
Lordship,
Am I correct?
Lordship.
Any other ground? I want to grant a bail, but this is not a ground.
Lordship.
If you have any other ground,
Lordship,
immediately I'll
my
dictate
main
the order.
grounds on, I'm focusing on that very section, Your Lordship. And,
According to this court, is not accepting your interpretation.
and the other ground.
Otherwise, whatever I see, how can the author limit of that 180 will be counted? What is Amir? What do you say?
Lordship, Lordship has rightly pointed out with
No, I may not be right. What do you say?
Lordship, if we look at the prayer of the petitioner, Lordship.
No, she has fairly admitted there is no other ground. You talk about, you just submit on this.
Lordship,
36 AB.
Lordship, since the prayer of the petitioner herein is to quash and set aside the impugn order that was passed in the NTPS.
That's what I'm saying. It's not a bail, it cannot be a bail application. Is it a bail application?
It's a bail application.
So,
And they want to.
If you are,
Yes, Lordship.
there is two hurdles. One is prima facie, your interpretation is not correct.
Lordship.
Number two, if you are challenging the order, whether bail or other thing,
Lordship.
revision I think lies.
Lordship.
So you have to
Lordship.
file a revision.
Lordship.
Because basically you are saying that the special court has misinterpreted
Lordship.
the provisions. Is not it? Any other ground, I'm ready to grant. This court is ready to grant.
Lordship, the other ground that I've praised before the honorable court, special judge is that. the
No,
accused
not before
person-
this court, not the special judge.
the-
We are not
the-
reviewing his order.
The accused person,
Where on the bail jurisdiction? This court is on the bail jurisdiction.
Lordship, this bail petition itself is defective, as Lordship has rightly pointed out. Lordship, let them withdraw the bail petition and file, since they have,
Your Lordship may.
in the
give
prayer, they
me
have
an opportunity.
clearly stated that to quash and set aside the impugn that was passed in the NTPS special judge. Kohima.
Have you, do you have the CD?
Lordship, I have the CD with me.
CD. What does it say?
It says that the matter has been forwarded. to
Any
FSA as of now.
Indictment? Any incriminating materials?
Yes, Lordship, Lordship, they have already seized the commercial quantity, Lordship. The quantity itself is commercial, Lordship. It is under section 22C, Lordship.
22C.
NDPS, Lordship. 22C.
Your Lordship, for that matter, if this honorable court may kindly give me an opportunity to brief out the fact of the case.
No,
Yes, Your Lordship.
no. What is it? I'm just
Your
asking. I want you to, what are the grounds? Except, these are the only grounds.
Yes, Your Lordship.
You are challenging the order of the special court. You file a review petition, revision petition.
Lordship.
Criminal
Lordship,
revision
on
petition.
medical grounds also, Your Lordship, there is a medical ground, Your Lordship.
It's NDPS. What are the medical grounds?
Your
What
Lordship,
is
the
the-
accused person is an HIV positive patient, Your Lordship.
No, that will be taken care by the jail authority.
Lordship.
Where is that medical prescription? There's no medical prescription. Have you annexed? Nothing.
Lordship. They have taken the ground in the special judge NTPS Kohima, Lordship. And that was rejected by the page 26, Lordship. Page 26 is,
No, that I've seen.
they have taken the ground, Lordship. Page 26 in the order, Lordship.
Has this been taken care of?
Paragraph, third paragraph, Lordship.
Stating the accused is a HIV patient does not indicate name of the accused, not the defendant, and the name of the accused is HIV. Where is the document, medical document?
Lordship, I have a copy of the medical document.
Why you have not annexed this? What does it say? It says accused is an HIV patient.
Yes, Your Lordship. Yes, Your Lordship. And even in the year 2021, he was undergoing, he is also a TB patient, Your Lordship. And he was continuing medication since 2021, regularly taking medication, Your Lordship. But since his arrest, the inception of his arrest, he couldn't go further. And in the
Angami, in that case, you take care of the health of the accused.
Lordship, definitely.
And Your Lordship,
I will-
in this instant case, the accused was arrested only on the statement of accused two, Your Lordship. And there is nothing was seized from the possession of. the
Madam,
accused
these are the
person.
matter of trial.
Lordship,
You have only 2 grounds
Lordship.
or 3 grounds. Innocuous, 2 grounds, no medical ground, nothing. Read your grounds, page 8. Basically 1 ground which you have submitted, that's all. No medical ground. Read it.
And moreover, Lordship, the petition itself is defective, Lordship, as Lordship pointed out, Lordship. So,
You think
If
about
the-
it.
yes,
See, there must be some ground to release you on bail. At least whether accept this or not, there must be some other ground. Which may be pleaded in the petition. There is nothing except the 36A.
Your Honor, may I?
Either I'll grant you sometime or you will withdraw or will dismiss it. If it is dismissed, you may have another impediments for filing subsequent application. But if you withdraw it, there may not be a bar to file a subsequent application.
Your Lordship, since the provision says that when a person is on the expiry of judicial detention, upon or even prior, then since the charge is under NDPS Act Commercial, then the Chief Judicial Magistrate, upon or at any time before the expiry of the period of detention authorized to him, he shall order such person to be forwarded to the special court having jurisdiction. That is my submission, but that was not
No,
done in this.
no,
case,
if that is the case, it's a matter of revision. You file a revision petition and with a prayer for bail or along with the bail with more grounds, bringing out more grounds. Why I'm saying so? Because you are relatively a young lawyer. Huh? Otherwise, had it been some senior lawyer, I would have not dismissed the matter. Because there's no other ground. Do you agree? Your ground 1, 2, 3. Think about it.
in fact, the Lordship is very considerate.
I don't want to dismiss it because it may have some create problem for next remedy. Or we'll keep it pending or we'll dismiss or will you withdraw? I'm not forcing you. You decide. I'm just giving you a chance,
Your Lordship,
another chance.
one opportunity may be given, Your Lordship.
Okay. You return the CD.
Lordship.
MS heard MS that is considered by the petitioner. After arguing the matter, after arguing the matter, at some length, you heard so PP, huh? After arguing the matter, at some length, the learned counsel for the petitioner. Is that the matter may be Even after 1 week
Yes, your lordship.
or 2 weeks,
2 weeks time will be given.
2 weeks. This stuff, we are not being opposed by the land constituted. Public prosecutor. Praise the Lord. List is made after 2 weeks. The learned PP is directed to retain the case diary till next date. Or should I say, is it necessary? Because it may hamper the investigation. What is the stage of investigation?
Lordship, the matter has been forwarded to the FSM.
So why not by the last order you delete? Because it amounts to interfering the investigation. So you do as permissible under the law.
Lordship.
You think about it, read again and again. It's a prime view of the court. I may be wrong.
Oblige, your lordship.
Maybe Lordship.
Yes.
Lordship, it's nothing on Tuesday, Lordship.
Yes, Lordship.
Looks like we don't have much time, Lordship. Moreover, my senior,
I can be here till 4:30.
Lordship, but due to some other work, my senior had to leave, Lordship.
On
You can
Tuesday,
take on
Lordship,
Tuesday, Lordship.
the 1st of August.
On the prayer of the learned counsel for the parties. You just heard Mr. So-and-so, learned counsel for the petitioner, and also Mr. Posiko Pote, learned counsel for the respondent. Next prayer, on the prayer of learned counsel for the parties, this matter
On
next
Tuesday,
week, on Tuesday.
1st of August.
01/08/2023.
Oblige, your lordship.
Bless my Lord.
My lordship,
Yes,
this is the IA filed by NIA for vacating of the stay. This honorable court granted the stay of the proceedings of the trial matters before the special court. My lordship. The petitioners, this is the matter stage in the
who is
year
appearing for the respondent?
I am the respondent number 1 and 2 in repeat. My lordship.
Who is the petitioner?
Petitioner here in one council appearing Siddharth Borban, my lordship. But,
With this.
AP Jamir is the petitioner here in this petition, my lordship. He is in the accused number 4. He is in the accused number 4 in the trial matter.
This is petitioner is your petitioner.
My lordship, in the IA, I am the petitioner NIA for vacating.
Okay,
In item number 36,
Okay.
NIA is the petitioner. But original in item number 37, we are NIA as the respondent number 1 and 2, my lordship.
which order the vacation?
My lordship, this honorable court passed the order on 6/8/2018.
Where is this? Page. Where's the petitioner for counsel for the writ petition? Where's the order?
My
Sir,
lordship, the order, this court has passed the order on 6/8/2018, my lordship.
have you not annexed it?
This is the order sheet of this honorable court, my lordship.
No, have you annexed in this?
NIA is not annexed, my lordship. That is the record of court original, my lordship.
What to do? This petitioner,
Kindly vacate the stay, my lordship, and fix the final hearing for matter on 8, my lordship, we have to dispose of this matter, my lordship.
Writ petition.
Writ petition, my lordship. Kindly vacate the stay, my lordship.
So once that is vacated, this will become infructuous.
My lordship, if this stay is not vacated, the trial is infructuous there in the trial court due to since from 4 years. Since from 4 years, already 3-4 witnesses are died, my lordship.
What is that order? Interim order, which date?
6/8/2018, my lordship.
6/8. Writ petition is what? For quashing?
Not my lordship, they are challenging the order of the notification of declaring of the NSNK is the banned terrorist organization as scheduled, first schedule item number 39. They are challenging that, but that is the provision is there, my lordship. They are bypassing those provisions, they come to directly before this honorable court. Before come to this court, they have to be filed application to the government of central government. Central government, if rejected, again it is to appeal provision to the review committee. Again, review committee will decide whether the prima facie materials is available to constitute this organization to be banned or not. Then pass the order, then they decide to as a writ appeal come to this.
The problem is where is the petitioner?
They are not, they are always doing, my lordship. Therefore, vacate the stay and fix for final hearing, my lordship, kindly dispose upon 8th and 8th of August.
That would be too harsh.
My lordship, my request, my lordship, one after one, my witness.
Because the vacating is as good as reviewing the order of this coordinate bench. So it has to be heard, both the parties.
My lordship, kindly otherwise fix on 8th August, my lordship.
You inform the.
I will inform, my lordship, kindly fix.
The petitioner for, learned concept of the petition.
He is from Gauhati, I will inform, my
It's from Gauhati. You make on the prayer of.
And also note absence of petition.
So we'll say, heard. Not appears for the petitioner on call list of Mr. So-and-so, N.N. Misra. Satyanarayan. Learned senior PP for the applicant oblique respondent.
Respondent number hearing 1 and 2.
Respondent number 2.
1 and 2.
1 and 2 in the writ petition.
3 and 4 in the Union of India. They are also present by my colleague.
Praise for vacating the interim order passed by this court. Mr. However, one more chance is to be given to the learned counsel of the petitioner to appear before this court for
8th of August.
In the interest of justice, this continue. However, in the interest of justice, one more chance is granted to the learned counsel of the petitioner. Mr. In view of the list this matter on 8/8/2023 for hearing. Is it for hearing, no? For hearing, huh? You make a mention on the tell your friend that the writ petition will be disposed of on that day. You pray for disposal of the writ petition.
Before that, my lordship, this bench has heard twice. After that, bench is changed. Again, come to the press hearing, my lordship. That is happening here.
This bench has heard this.
First time is heard once. Again, bench is changed. Last 2021-22 also heard by the other, my lordship. After that, this petitioner is submitted that.
That's why one more chance.
Therefore, my lordship, on 8th, I will hear the matter, my lordship, and also intimate my central government.
Please inform your friend.
Please, my lordship.
Have you corrected your affidavit?
Yes.
The present subject matter pertains to industry seniority.
I've seen it. 23.
So my case, Lordship, in brief, Lordship. The petitioner entered into service in the year 2000. And the paper respondent number 4.
What is it? Can it be taken after 1 week or 2 weeks?
Lordship.
Can it be taken after 2 weeks? Or 1
Lordship,
week?
the urgency is my junior is in the higher post.
Yes, that I have understood.
If your Lordship have difficulties, then fix it on Monday.
In fact, no difficulty as such for hearing the matter. But I have some urgent work today.
Then fix it on Monday, Tuesday, Lordship. It's a fixed
Tuesday.
setting.
My lord,
Because it's a matter of 2022.
Yes.
Had it been an old matter, I
Sure.
could have.
may I please, lordship, my lord, let the
Despite
matter
my
may come up on Thursday, my lord.
Tuesday.
Thursday. Monday, Tuesday, I have difficulties.
Matter is very simple. You can see, will pass the consent order. Huh?
It is spurred by delay in latches, your lordship. That is my only case. And
Huh?
it is spurred by delay in latches on the part of the petitioner, number one. Number two,
When was the that seniority, impute seniority list?
2018.
2018, which came to the knowledge of the petitioner only in the year 2022.
Okay.
He is an
That was
officer.
never published, Lordship. So that matter, Lordship, I'll satisfy your Lordship.
So your defense is only
Then and natures.
principle of, I mean,
No,
the,
your lordship, on the basis of joining also, after we were promoted, I joined earlier than him. And then secondly, on the issue of delay and latches, thirdly, he's an officer. He's an officer.
it's supposed to be
And he's
vigilant.
supposed to know everything. He is supposed to be vigilant. He has not been vigilant. Thirdly, promotion is in accordance with the service rules.
So,
And on the basis of the merit also. So all the records are there.
This court,
So the,
this court would like to adjudicate the matter,
yes, your
but
lordship. Your lordship.
Thursday.
Your lordship, I have no objection. No objection.
Third. On the prayer of the landed council for the parties. You just heard Mr. What is a landed council for petitioner. Mr. So-and-so for state respondent, landed council, landed district council for state respondent, Mr. Tampak Pogregar for respondent number 7. On the prayer of the land council of parties, list this matter for hearing on 3/8/2023.
that's a fixed item. Lordship.
2022. Because some other court may be there, so I cannot just fix it.
Senior officer is working on the junior officer, Lordship. That is the urgency. Senior officer is working under the junior officer.
Okay. That's why we have fixed it for hearing.
Yes. Public, much of like.
From this section, go to over.